Good evening. Welcome to Good evening. Welcome to another episode of Uncommon Sense with Jose Negron. Now, for the benefit of those of you who are not familiar with the channel, okay. Good evening. Welcome to another episode of Uncommon Sense with Jose Negron. I apologize for the technical glitches. I'm using my tablet to do the stream. But in any case, welcome to another episode of Uncommon Sense with Jose Negron. Now, for the benefit of those of you who are not familiar with the channel or watching this channel for the first time, the reason why it is called Uncommon Sense, because here on this platform, we discuss everyday issues where we try to find logical solutions, but not everyone uses logic. So for that reason, it is called Uncommon Sense. I just want to let everybody know that I'm currently live on YouTube, Facebook, and Twitter and Twitch. I also want to let everybody know that the subscriber mode has been enabled. What does that mean? That means that if you're not a subscriber and you wish to enter a comment in the chat, you need to subscribe to the channel. And already, excuse me, we have a comment from someone named USA. Okay, I don't know what. Okay, it says here the Supreme Court has been good recently. No more baby murders, no more racist policies, supporting our rights to defend ourselves, etc. So, as you can see, the topic for tonight is in regards to the Supreme Court. Okay, so before we get into this topic, there's a few things that I'm going to be discussing. Okay, just give me a moment. Okay, so what we're going to do is we're going to have another round of In My Words. Okay, now I have to apologize for last night. There was some confusion in regards to the stream. What? Let me explain. What that was, it was a rebroadcast of another stream, which I did, addressing the people who hate others. Okay. Good evening, Blazing King. Thank you very much for stopping by. So, um, just to let everybody know what I'm going to be doing on a regular basis, I'm going to be airing rebroadcast of some of the streams which I have done. Okay, this is going to become a regular occurrence here on this in this platform. The whole purpose behind that is to give everyone an opportunity who did not catch it the first time to catch it the second time. And for those who did catch it the first time, they can catch it again. Okay. So I'm going to be doing that most likely no more than once a week. So the next rebroadcast will be a stream that I did in honor of my mother and her passing. In fact, next week will mark 3 years that my mother passed away and became an angel. As you will find out, as you see the broadcast, um, it was an emotional stream. Okay, and I was very hesitant um, to air it, but I wanted to do something in honor of my mother's memory. Okay. Thank you, USA. Okay. So originally it was going to be rebroadcasted on Wednesday, which would have marked the anniversary of my mother's passing. But I'm going to be doing a live stream on Wednesday night. So that's going to be pushed to Thursday at 9 o'clock. Okay. And just to let everybody know, I did get emotional because um, it was still very fresh in my memory regarding her passing. So, also, one thing I want to get off my chest, and one thing I'm going to be doing quite often. Okay, I'm going to do my best to avoid saying anything about anyone who's physically not here, either in the chat or on the panel, to give a rebuttal. Okay, it's not out of fear, it's not out of fear of reprisal. It's more of a courtesy thing. Okay, um, I think it's very immature to saying nasty things about a person behind their back. If you're going to say something nasty to a person, then you should say it directly to the person's face, or the closest thing, which is say it when the person's on the panel. Okay. Unfortunately, we have had a lot of that going on in these YouTube streets. So that's something that's not going to happen. Okay. Um, Next month will actually mark 2 years that I've been a serious YouTube creator. So I'm going to try to plan something special to mark the anniversary of the launch of my channel, Uncommon Sense with Hussein Lebron. And what I'm going to be doing is of course, I'm going to reach out to the people who have appeared on the platform on a regular basis. Also, I'm going to extend an invitation to some others to either pop on the panel or just to say a couple of words. The fact of the matter is, I find it hard to believe that it's been 2 years since I've been a serious YouTube career. Okay. Now, another thing I'm going to try to do, um, maybe try to get in some more interviews with some of the positive YouTube creators. Um, so first of all, to let the uncommon folk know who they are and give them their day in the sun so they can shine. Because um, I can say this, it takes a lot of work to do what we do, and it's sometimes it could be a thankless job. But in any case, also I'm going to try to keep this no more than 90 minutes because the Radical Latino has a stream going on tonight at 9:40, I think. And unless I'm mistaken, Dynamondo has a stream going on as well. So um, I'm going to try to catch his stream on the playback. Okay. So, and of course, I'm always willing to accept constructive criticism. Okay. I don't fear that. Now, being that next week, um, I'm going to be devoting a good deal of time in the beginning in regards to my mom. Um, she was the main force in the type of person I am today. So you're going to see a different entry. This is what you're going to see. I apologize. I think I'm gonna have to go back to using my cell phone to do streams because the reaction, as far as this tablet is concerned, is very slow. Okay, so that being said, we're going to get into the main topic. Okay, so as you can tell, the main topic is has made some decisions. One of them regarding affirmative action. Another one has to do with defeated the attempts of President Joe Biden to have some sort of student loan relief from student loan debt. Also, another case that has to do is reproductive rights. So what I'm going to do is I'm going to play an audio of a clip of a recording from NPR, and basically what they're assessing what is going to happen now with colleges in regards to trying to increase the sophistication on the student body. So before I play the audio portion, I just want to make it clear that this is fair use, fair use, fair use, and the purpose is to give a critique, not to steal credit. Okay, so let me just 1 moment.
With the heated discussion of a Supreme Court ruling, we have some preliminary answers to how that ruling affects university admissions.
The court majority rejected elaborate policies at Harvard and the University of North Carolina. Both elite schools looked at race as one factor in the admissions process. The ruling says that violates the Constitution's requirement for equal treatment regardless of race. Dissenters said the Constitution promises equality, and it was all right for schools to act on that promise.
NPR's Alyssa Nadworny is here. Good morning.
Good morning.
First, how did the court explain its ruling?
So Chief Justice John Roberts wrote the majority opinion, and he said, however well-intentioned the policies at UNC and Harvard were, they failed to use race within the narrow confines of what the Constitution allows. He did leave the door open, writing that schools could consider an application's discussion of how race affected his or her life. I talked about this with Sarah Parshall-Perry. She's a senior legal fellow at the Heritage Foundation, who was encouraged by the decision.
The court is clear that universities can consider an applicant's discussion of how race affected their individual lives, but we will no longer see individuals checking a box or being subjected to a college or university's quota system.
So universities don't really have quotas, but Harvard was using a point system to rate students' identities.
And this is the thing the court says is wrong now. If you had an individual experience with race that you want to talk about in your application, you can do that, but you no longer get credit, the court says, for being a member of a group, so-called. What are colleges and admissions professionals saying about all that?
So even though it was expected, it's a major blow to colleges who are committed to diverse campuses. I talked with Angel Perez. He leads the National Association of College Admission Counseling.
Today's decision is going to make it a lot harder and a lot more expensive for institutions of higher education and admission officers to bring in a diverse class.
He points to the University of California. There, it took decades, a complete admissions redesign, and hundreds of millions of dollars to try and get those diversity numbers back up after the state's affirmative action ban in the late 1990s. He says most states, most colleges don't have that kind of money or political will.
This is an interesting point because you're telling me that universities, in response to this, are not saying we're abandoning diversity. They're saying we're going to try to get diversity in some other way. Does this affect every university?
Well, it is a nationwide ruling, but most schools are open access. Think community college, lots of, public four-year schools. Only a small portion, about 200, have highly selective admissions where this decision would apply. But what happens at elite institutions matters. They're gatekeepers to power in America. Take the Supreme Court justices. Currently, 8 of the 9 attended law school at Harvard or Yale.
What does this mean for high school students who might be applying to college soon?
I spoke with Sanjay Mitchell. He's a longtime high school counselor in Washington, D.C. He's been working with the students already to kind of reframe their essays to touch on their lived experience. But he says this whole thing has caused a lot of anxiety.
So students are asking the questions like, well, does my identity not matter anymore? Does that now mean that we are only going to be relegated to HBCUs? And those are the thoughtful responses, Elisa. The other kind of responses that we're hearing is, well, I guess they really don't want us to go to college. Well, they always say that college isn't for everyone.
HBCUs, historically black colleges and universities. What can colleges do within the law now to improve diversity?
We can expect an increased focus on that essay, recruitment, expanding financial aid, including free college programs, and colleges may go test optional. But, over and over, research has shown that nothing is as effective at creating a racially diverse student body as considering race.
NPR's Alyssa Netborny, thanks so much.
You bet.
Okay, look, I think it's going to take years before we get the actual fallout regarding this decision. I think in some ways it's troubling, in some ways it could be a mixed blessing in disguise, in the sense that it might motivate people to try to do well in their classes and apply some discipline in order to enter the schools that they wish to attend. Now, as the audio indicated, there is roughly about 200 universities and higher level forms of education where they're very high, very competitive to enroll in these universities, such as any of the Ivy League schools like Columbia, Harvard, Princeton, and other similar places of higher learning. It may compel students to be more creative as far as describing how their ethnicity have affected their lives, things of that nature. Now, the whole point and the reason behind affirmative action is an attempt to address certain wrongs that was performed, where students were not granted the opportunity to enroll based on their ethnicity. Okay. As I stated, it will take us time to actually know what is the actual result as it comes to this topic. Okay. What I will say to anyone that's thinking about pursuing a university education, it is possible to obtain one, but I think what's going to happen is it's going to be more competitive. So you really need to apply the discipline needed in order to do well. Okay. Of course, extracurricular activities play a role, and also your ability to articulate for yourself and describe yourself what type of individual you are. So, what we're going to do is, just give me a moment. Okay, so what I'm going to do is, this is another decision that the Supreme Court made, okay? And it has to do in the area of religious combinations, okay? This is another decision that was made, let's see, today's, about 2 weeks ago, okay? And this involves a youth, a postal worker that was instructed to work on Sundays. The postal worker objected because he is a Christian, and this person to work on Sunday is in violation of the Sabbath, which is a day where you do not work, but you spend time and energies focusing on God. So this came from the website of the Magnolia Tribune. Unfortunately, I cannot share because I don't want to share using my time. But let me just read to you the facts of the case. In 2022, Gerald Ruff brought a case to the United States Supreme Court, which he argued should not be required to work on Sundays because of his religious views. Ruff, a Pennsylvania resident, worked as an auxiliary mail carrier for the U.S. Postal Service. Ruff sued the United States Postal Service under Title VII of the Civil Rights Act of 1964. He claimed that his USPS position generally did not involve Sunday work, but that changed after the USPS agreed to begin facilitating Sunday drivers for Amazon. This caused him to seek accommodations for his Sunday observance of the Sabbath. Ruff received aggressive discipline for failing to work on Sundays, and he eventually resigned. Now, Title VII requires an employer to accommodate for religious practice unless they can show accommodation results in increased costs. The case went to the district court in which summary judgment was granted to USPS. The Third Circuit Court affirmed the decision. That court agreed with the federal judge that exempting Ruff from work on Sunday imposed on his coworkers disrupted the workplace and workflow and diminished employee morale. The court cited hardship at more than the minimus cost in the opinion. It was the unanimous opinion of the U.S. Supreme Court that the hardship required for employers to deny religious accommodation needs to be substantial. An employer must show the burden of granting an accommodation will result in substantial increased costs in relation to the conduct of its particular business. Justice Samuel Alito wrote in the opinion for the court. Alito referred to a former case, World Airlines versus Harrison, saying that the hardship clause cannot be reduced from 1 phase. The opinion thoroughly clarified the Title VII standard regarding hardship in order to provide context to their opinion. The High Court ultimately sent the case back to lower court. Justice Alito wrote, having clarified the Title VII under the hardship standard, we think it's appropriate to leave the context-specific application that clarifies standard to the lower courts in the first instance. The Third Circuit assumed that hardship prescribed on more than a minimum cost test, and this may be led to court to dismiss in the more possible combination, including those involving the cost of incentive pay or the administrative cost of coordination with nearby stations with a broader set of employees, without foreclosing for the possibility that USPS would prevail. We think it's appropriate to leave the rules ones to apply all clarified context-specific standard and decide whether further action development is needed. So eventually, this individual left the United States Postal Service in regards to this. After filing the suit, Ross was backed by a Christian organization, other religious groups such as the American Hindu Coalition, the American Sikh Coalition, and the Council of American Islamic Relations also showed support. Okay, so basically what we have here is that the Supreme Court indicated, at least in this case, that an employer must allow individuals accommodation as regards to the religious views as well as observing the Sabbath. One thing we have to bear in mind that now when it comes to the members of the Jewish faith, we have to allow them to leave employment, their jobs, so that not time to observe the Sabbath. So we shall see what will happen in the future. So, of course, let me just remind everybody that the link to join the panel has been pinned. So if anyone wishes to join the panel, they may do so. If anyone wishes to make any comments, they may do so. If no one enters a comment or joins the panel, then I will start the show. Then I will start to wrap this up. Let's see. Let's give me a moment. Okay. This bit of me just trying to. Okay. Okay, so now what I'm going to do is I'm going to be. Good evening, Irby. Thank you very much for stopping by. So the topic for tonight is let us examine the Supreme Court. So what we're doing is we're talking about certain decisions which were made, which appears to be controversial. the first thing we discussed was overruling affirmative action. So basically, colleges and universities cannot use race as a major factor in determining admission. However, they left the door open for students to discuss how they were affected by this. So now what I'm going to do is I'm going to okay. Of course, many of us are familiar with Roe versus Wade, which allow reproductive rights in the form of abortion. Okay, which meant that women have the right determining their pregnancy at any point they wish. Okay. However, that decision was overturned last year. So let me just read the article. That's okay. Now, in the U.S. Constitution, according to Supreme Court in Dobbs versus Jackson Women's Health Organization, the Supreme Court overruled Roe v. Wade, which guaranteed a constitutional right on abortion. Some state constitutions, however, independently protect abortion rights. In Roe v. Wade, the Supreme Court decided that the right of privacy implied in the 14th Amendment protected abortion as a fundamental right. However, government retained the power to regulate or restrict abortion access depending on the stage of the pregnancy. And after fetal viability, outright bans on abortion were permitted if it contained exceptions to preserve life and death. For the following 49 years, states, healthcare providers, and citizens fought over what limits the government could place on abortion practices, particularly during the second and third trimesters. But abortion was fundamentally legal in all 50 states during that period. Writing for the majority in Dobbs, Justice Samuel Alito said the only legitimate unenumerated rights, that is, rights not explicitly stated in the Constitution, are those deeply rooted in the nation's history and tradition, and implicit in the concept of ordered liberty. Abortion, in the majority field, is not such a right. Following Dobbs, reproductive rights are being decided in states, state by state. Constitution is in 10 states: Alaska, Arizona, California, Florida, Kansas, Massachusetts, Minnesota, Montana, New Jersey, and New Mexico has been interpreted by state courts to guarantee the right to abortion or protect access more strongly than the federal constitution. Other state legislations have been passed protecting abortion rights. Many states, however, have made abortions illegal. Basically, what happened that it was left to the states in order to make a determination when it comes to reproductive rights. What does that mean? That means in states where it's quote unquote blue, such as New York, New Jersey, mostly the states in the Northeast, California, Oregon, Washington, and other blue states, reproductive rights are more or less guaranteed. In other states, when they're red, like Texas, Florida, and other red states, there have been a great deal of restrictions as it pertains to reproductive rights. And of course, those who are in the pro-life movement, like myself, are very happy regarding this decision. Those who are in favor of reproductive rights Obviously, I'm not happy. Okay, because instead of going to a national guarantee, states are left to make the determination to codify or to limit reproductive rights. Now, I'm going to get on my soapbox a little bit, okay? I thought it is my platform, I can say and do whatever I want. Okay. When this decision came down, you hear the Democrats going bananas, going crazy about it. But one thing that the Democratic politicians, the Congress, the Congress, the Senate, and the White House failed to do was to codify reproductive rights. What that meant was that basically, no matter what, once it's been codified, it's a law. It cannot be changed, no matter what. For whatever reason, they have 49 years since Roe v. Wade became the law of the land to codify reproductive rights. And they failed to do so. Okay. So, excuse me if if I feel weird or funny or whatever. Okay? Whenever I see Democratic politicians, raising an uproar regarding reproductive rights and all that, and how they're being infringed, where they had numerous opportunities to codify reproductive rights, and they failed to do so. So, all I'm going to say is, miss me with the BS. Okay. We shall see what is the consequences in regards to this issue. Now, what I'm going to do is I'm going to share further down how we arrived at this decision regarding Roe v. Wade. Abortion was illegal in most states in the 1960s, often with no exceptions for the cases of rape or threat of life. A pair of high-profile cases, however, shine a spotlight on the impact on these restrictions. Beginning in the 1950s, thousands of babies were born with severe birth defects after their mothers took the morning sickness pill, dihalothomine, while pregnant. The most well-known case was that of Sherry Finkbein, a host of the children's television program Rumpelboom, who was forced to travel to Sweden to obtain an abortion. A Gallup showed that perhaps surprisingly, given the legal backdrop, that a majority of Americans supported Finkbein's decision. Shortly after the dihalothomine scandal, an epidemic of rubella or German measles swept across the country. Babies that survived rubella in the utero were often born with a range of disabilities such as deafness, heart defects, and liver damage. A rubella vaccine didn't become available until 1970. This was in the environment of maternal risk that high-profile doctor like Ellen Guttmacher began to publicly abortion should be treated like other medical procedures, a decision to be made between a physician and patient. So now I'm going to share with you a case regarding Griswold versus Connecticut. While thalidomide and rubella impacted public perspective on abortion, a series of cases built the foundation for the coming revolution in abortion law. The first involved the right of contraception, and the study begins in the 19th century. In 1879, Connecticut Senator P.T. Barnum, yes, that's P.T. Barnum, introduced a bill barring not only contraceptives but also the distribution of information related to them. The Barnum Act was still in the books in Connecticut in 1960 when the Food and Drug Administration approved the first oral contraceptive. Estelle Griswold, Executive Director of Planned Parenthood of Connecticut, was fined $100 for violating the law. Her appeal went all the way to the Supreme Court. In Griswold versus Connecticut, a 7-justice majority struck down the Barnum Act. Justice William O. Douglas explained that the Bill of Rights applied a right of privacy because they, when viewed as a coherent whole, it focuses on limiting government instructions. The Griswold majority held that the government cannot prevent married couples from accepting contraception. With time, the justice did not extend the right to unmarried people. Griswold's contention that the Constitution creates a zone of privacy into which the government cannot enter paved the way for war, among other landmark decisions. Now, what? Okay, I'm just going to. Now I'm just going to talk about the opinion itself. Okay. The Supreme Court handed down this decision on January 22nd, 1973. 7 of the 9 justices agreed with the Due Process Clause of the 14th Amendment, which says that no state shall deprive any person of life, liberty, or property without due process of law. It implies a right of privacy. The majority seized upon Wellington's definition of liberty, citing a series of prior cases indicating that the term liberty must be interpreted broadly in every society. Okay. Good evening, Don Armando. How are you doing today? Same. You know what? I'm gonna have to go back. Okay, good. You know what? I'm gonna have to go back to using my phone because Apple is not doing what I needed to do. Okay. The justices did recognize that the state could place some limits on abortion if necessary to further a compelling state interest. The state's ability to regulate increased as a pregnancy progressed. And after a fetus reached viability, the states could prohibit abortion except when necessary to protect life or health. Justice William Rehnquist and White dissented. Rehnquist argued that the primacy in the Constitution sense legal search procedures had nothing to do with abortion. In his view, since abortion bans implication of no fundamental rights, it must only have some rational basis, such as protecting a fetus. Foreshadowing the Dobbs decision in 2022, Rehnquist also declared that the voting records of rank are explicitly listed in the Constitution those with deep roots in the American legal tradition. Actually, I enjoyed the restaurant. Thank you very much. The food was good. And actually, we did have a great time. To chew the fan, to talk about other things. Okay. So what I'm going to do is I'm going to stop here. Okay. Let me just state the following. Throughout. Oh, okay. Okay, cool. So look, throughout the history of the Supreme Court, they made various decisions. Some perceived to be very good, some perceived to be very bad. Okay. And the fact of the matter is, whenever you have any group of people um, who are given the authority to interpret the Constitution, there are going to be times where the interpretation is going to be on money, and there's going to be times where the interpretation is not on money. I mean, and I see here we got tonight is a very active night because Fighter has a stream, Misunderstood has a stream going on right now, and also Miami Stand Radical Latino also has a stream. Now, one thing I neglected to do earlier when I did my discussion was the fact Radical Latinos petition to have not only Latinos but biracial, multiracial mixed people to be included in the census. Okay. Now, what I did was there's a link to the petition itself in the description of the stream. So what I'm going to ask all of you to do is to consider if you signing the petition, and if you are so inclined, share it with other people. Okay. Why am I asking everyone to do this? Because we all need to have our own identity. We all need to be able to have our own community. Okay. Now I know there might be people that have an issue with that. People have certain perspectives as regards to biracial and multiracial people. What I'm going to ask that you do is, before you make any rash decisions or judgments, observe them, try to get to know them, and then you can make your decision as it pertains to the biracial and multiracial community. Which brings me to tomorrow's stream. What comes on? Friday's stream. Okay. So on Friday, I'm going to be doing a stream, and the topic is how to deal with people who are different. Okay. And I think it's a good topic, because what we'll do is help us to focus on the many diverse types of people that we see on a regular basis, and how to deal with it, how to interact with such people. Okay, because unfortunately, this country does not have a good reputation of dealing with people who are different. Okay, and unfortunately, there are many examples of this, such as the so-called indentured servants, which were basically was chattel. Okay, also the fact that when it comes to various treaties, most of them were broken. Not to mention the prejudice that various ethnic groups have to deal with. So we're going to have a discussion on that on Friday at 10 o'clock. Okay. So I would encourage all of you to either catch it live or catch it on the playback. Okay. Now, one thing I gotta admit, which I find to be very odd, Okay. Out of all the streams I did, all the call-in shows that I've done, the ones that I've done you know, the highest numbers of views have to be when it has to do with race or people arguing on the platform, um, or similar topics. Okay. I generally don't try to do retro streams. Okay. There are other people that do a better job than me. That's never been my cup of tea. And as I alluded to earlier, going forward, I'm going to do my best not to make comments regarding people who are not here, okay? Because they're not here to give a rebuttal. So just out of out of courtesy and out of respect, that's something I won't be doing. I won't be doing here. Okay. With that being said, I will be planning my streams for next week. Um, I will be sharing what's going to be the topic as far as the stream for Tuesday next week, Friday's stream. Okay. And and I understand that not every stream can be exciting. Not every stream can be what have you. I mean, it is what it is. But considering all the stuff that's gone down with these decisions of the Supreme Court, it was time to have a discussion. So that being said, since no one else is going to comment in the chat, and leave and just rambling. I do appreciate the people who are watching this right now. Thank you very much for the love and support. And it doesn't hurt for you to hit the like button. Okay, it's not like I'm asking you for a donation to the Cash App. Okay, but in any case, I'm gonna wrap this up so I can get ready for Radical Latino stream. So, what is my final words when it comes to all these decisions? The fact of the matter is, the Supreme Court is made up of people. No one's perfect. Okay, people can make mistakes. However, whatever the decision they make will affect us for generations. So that's something that we have to bear in mind whenever we do vote on who's going to occupy the White House, because they will determine to a certain extent how the court will lean. Okay. With that being said, a huge shout out to everyone who appeared in the chat. Don Armando, Herbie, USA, and Blazing King. Okay. So, in any case, thank you very much for all the love and all the support that you're giving me. And as I stated before, I will plan something special next month to come to celebrate the second anniversary of the platform. So that being said, I want to thank everybody else for your time, your energies, and your devotion. If you wish, you can enter a comment after the stream is over, just keep it respectable. Okay. With that being said, thank you very much, and let us be good to one another. This has been another episode of Uncommon Sense with Jose Negron. Wishing all of you good night, take care, and peace.
Get strong, get strong. Get strong.